With a friend of ours in Plymouth, they had to see a psychiatrist, and he gave the report that the court wanted to hear. Then they got permission from the court to have the report of the psychiatrist critiqued, but they had one or two other psychiatrists who they named. They wanted to look at it, but once they saw who it was who made the first report, they dropped out. They didn't want to do it.
I know a paediatric radiologist that was given first X-ray and was asked to make an opinion of how I thought the fracture occurred. He didn't even see the child involved in that fracture, so it was non-accidental injury. Didn't see the parents. Just actually given a set of X-rays and asked to make a medical opinion.
Well, what it is that there are a lot of problems with expert evidence, a massive problem with expert evidence. But I think we're making progress in getting recognition that it's a problem.
With that psychiatrist, a member of ours had the same psychiatrist, and when we compared the CVs, they were totally different.
Well, there are all sorts of issues there.
CVs can be elaborated. This one who advertises on television to be an expert on every topic in psychiatry. Yeah. She does 100 court reports a year, £1,000 per report, 20 court hearings, and a full-time job.
Yeah.
John, I've got lists of second medical opinions with reference to doctors and paediatricians, and that's brilliant.
I haven't got it, but I'd like to have it. We need a central, basically we need to know experts who actually do know something.
You can't have got three.
but again, the strength that I have is that I do get a budget from the taxpayer to employ staff who can coordinate bits of paperwork, which Emily decided she wanted to do this area. Because this isn't the only thing I deal with, although I do spend a large proportion of my time on it. But what we want to do is collect that sort of information. But anyway, moving on from expert evidence, because if we don't move on, we won't finish by the time we have to finish, given some people have to leave. Court of Appeal documentation, we have managed to kick a few cases into the Court of Appeal. The Court of Appeal has not shown a lot of enthusiasm for challenging the lower courts. Again, the point that was made earlier about getting precedents set up so that people have got some of the work done for them is important. The points of law are critical, however, that if you're going to take something to appeal, you have to have a good point of law. When we talk about mental capacity, the fact that somebody actually does have mental capacity and has not been excluded is a good point of law. It's the failure to have a fair trial. And there are lots of, but it is absolutely critical that you get, if you are going to submit papers to the Court of Appeal as a litigative person or help somebody do it, you must make sure that somebody checks through what you're doing and makes sure that there is a point of law in it, that you've got a chance of winning it. If you don't understand, the phrase is used, the original decision has to be plainly wrong. There has to be something that you can say is wrong with it in law. Now we're halfway through submitting something that challenges the idea that just because a child's been with a foster carer for a period of time, you can't have the child back.
Is there on a full process or an interim period?
This is, it doesn't really matter because they're using the argument of permanency of placement. And there is, I don't really want to try and go into that now because it's too complicated.
So there is a case law that says interim care or a local authority doesn't allow them to use a period of time to establish a status quo.
Isn't it? That's
Gillespie, I think it is 1993.
Right, well that's very useful. Again, could you email me that so I can put it on the website? I do try to make sure that the website has useful precedents on it. Because if there are useful precedents there that people can use to argue their cases, that's a helpful thing as well. But if you could email me that, so I'm trying to make it, and I don't mind if somebody else has access to it if they're going to maintain the legal precedent side, but it's got to be approached so that it's useful research. Because what happens otherwise is you do all the paperwork and you get lots of bundles together, but your point of law isn't there, and therefore you can't win. And you need to find it. You need to find the point of law. As people will be aware, almost certainly, with the Court of Appeal, you need permission to appeal, which you can either obtain from the lower court or from the Court of Appeal. Judicial Committee of the House of Lords is in Committee Room 1. We are in Committee Room 6. My understanding is you can actually submit papers for a failed permission in the Court of Appeal. So in other words, if you go to the Court of Appeal for permission, fail to get permission, you can still submit papers to the House of Lords. You're in the process of doing that. Again, if you're going to succeed there, that's very difficult. And you really have to make sure that your law is right. Okay? I don't know. The Court of Appeal has had a tendency to have an establishment orientation and to not challenge decisions of the lower courts, even in situations where really they shouldn't. Part of that is because if they start, this is the whole point about the edifice that's been created. The edifice is such a disaster, people inside it want to